All right, okay. Thank you so much. I'm going to go back a little bit to the introduction. With this rapid pace of our ever-changing economic, political, and societal condition, it's crucial now more than ever that us attorneys that we keep track of the legal landscape and understand how several legal issues can overlap and intersect. Knowing what kinds of questions to ask our clients and what kinds of information to request from them, that is going to set our legal practice up for success each and every time. That's why today's topic is so important. Today, you're going to hear from several speakers. On a broader scale, information provided today will take your estate practice from another level to another level of overall quality. Even if you are new, if you're upcoming in your estate practice, or you've been here for several years, it's my belief that your practice is going to be enriched with the information that you learned today. And throughout the CLE seminar, Wills and Trusts, start to finish, you will be greatly enriched. Throughout the presentation, attorneys will have access to knowledge, tools, and resources to help support our clients with estate planning. We will discuss various tips and tools to help you gather the information you need to provide your clients with the best services. Whether it involves a power of attorney, will, trust, other estate planning, beneficiary information, this session will lay the groundwork for you moving forward in your practice. So today we present to you Wills and Trusts from start to finish. About me, my name is Sonia Murphy. I run a transactional solo practice in Memphis, Tennessee called Sonia Murphy Law. My past legal experience dealt with bankruptcy, consumer protection, and some estate planning. I also have legal background working in the federal government realm. I worked for the EEOC, Equal Employment Opportunity Commission, where I did some employment discrimination practicing, and the Small Business Association. There I did compliance, corporate compliance for businesses who are going through the COVID disaster process. And also how they were getting their emergency relief through the Small Business Administration. And then also working with taxpayers and contracts with the Internal Revenue Service. If you have any further questions or concerns during or after this presentation, feel free to contact me. My email is soniamurphylaw@gmail.com, or feel free to text me or call me on my business line, which is below. So an overview of today and my topic, what questions to ask your clients and why. So the overview involves, we will discuss ways to obtain the necessary information that you need, optimizing your law practice, ways that you can make your law practice more effective by getting all the information, all the details you need from your clients on the front end, and those considerations, tools that you can utilize, and we will also share some example templates and techniques towards the end. And then you will also have opportunities to ask questions throughout the presentation and also at the end. So feel free, if you need to jot down notes during the presentation, you can put it in the group chat, the team messenger group chat, like our producer has said, or feel free to save your questions to the end. However you're most comfortable will be fine with me. So beginning with current and future needs. All of us have needs to address in our lifetime. The majority of those needs are medical and financial. As estate planning attorneys, we will have to know how to do a power of attorney. You will do a healthcare power of attorney for medical concerns and financial power of attorney for financial concerns. Addressing your client's current and future needs is an essential part of the interview intake process, as it will guide you to the next steps in providing legal services. So when you're consulting with your clients, whenever they express certain concerns, they may not come to you and say, hey, I need a healthcare power of attorney, or hey, I need a financial power of attorney. They may be from rural communities. They may not know the legal lingo. They may be from inner city communities. They may not know the legal lingo. They may come to you and say, hey, my grandma just passed. There was a lot of family drama going on. We had cousins popping up saying they should pull the plug, and some cousins popped up and said that they shouldn't pull the plug. What can I do? And so from there, as an attorney, when you're intake and you're hearing these things, the light switch should go off, bam. We need to talk about healthcare power of attorney to help this person, because a lot of times your clients will come to you after they have seen something traumatic in their family circle or their friend circle where things did not go well. And they think about themselves and say, hey, I don't want that to happen to me or my children or my family. I don't want my family members fighting over money. I don't want my family members arguing about whether the plug needs to be pulled or not. And I'm using those terms lightly because that's how a lot of your clients will come to you, right? So with that being said, we're going to talk about the healthcare power of attorney, and then we're going to talk about the financial power of attorney. As you can see, and as some of you may know, the healthcare power of attorney is a legal document that will allow your client to appoint someone to make medical decisions for them when they're able to do so on their own. This person can be known as your healthcare agent or proxy or POA. They make decisions about your client's medical care, including consenting to or refusing certain types of treatments based on their previously expressed wishes. It ensures that the medical preferences are maintained and honored, even if your client can't communicate them directly at that time. So it's more of a proactive, preventative document to help solidify those medical preferences on the front end. So when or if that medical emergency arises, other third parties cannot deter from those preferences. When communicating with your client about this, here are some questions, discussions you may ask throughout. Okay, so I'm just going to give you a couple that's going to help you. You may ask your client, okay, yes, I understand something happened with your grandmother medically, and you're concerned that you don't want the family to have to go through that should you be incapacitated. Here are some questions I would like to ask you as my potential client. Are you familiar with certain life extending treatments such as ventilators, life support breathing tubes? Do you know what DNR means? Do not resuscitate. So those are some of those kind of questions you can ask. And they may be like, well, yes, I do know about this, but no, I don't know about that. And as an attorney, that's where you will take a pause and you will explain what each one of those means to your client so they know exactly what you are talking about. Conduct your consultation dialogue with open-ended questions. That will help your client loosen up. That will help your clients discuss their concerns with you. And as they are discussing their concerns with you, you are steadily taking notes and just kind of constructing and building what kind of services you're going to provide for them. Because most likely when they're talking about healthcare issues, they're going to want to do that healthcare power of attorney. Also, in communicating with your client, you also want to discuss the role of POA or who the proxy agent is and ask for recommendations. So with that being said, you have to make sure that you explain to your client, is there a confidant, a relative, a spouse, a close friend that you trust with your life who is dependable, responsible, trustworthy, and decisive? You want to ask if this person is easily accessible. Do they have great reading and comprehension skills? Are they mobile? Can they transport themselves? If so, then that individual should be the proxy. They should be your power of attorney. They should be the person on the document identified to make those decisions. If not, then your client needs to know there's some work to be done to ascertain who fits the description. This may take a few hours for them to decide and think about that, who that individual is. It may take them a few days. It may take them a few weeks to decide who fits that description. Ensure that your client understands. This can ultimately be the most important decision of their life because basically their life is in someone else's hands. Give your client time to contemplate this. However, make a reasonable follow-up timeline and stick to it. There's a healthy balance when it comes to providing the space and time for your client to think and establish those healthy expectations, and also to keep focus on the project and make sure that the job is done. On another note, it's a great practice to research any new legal updates periodically to see if anything relevant has changed. So with discussing the role and asking for recommendations, let your client know, hey, who's the potential names? Who do you know? And give them options as a primary and a backup in case the primary person is not available or the primary person has passed away or is just not available. Give them an option for a backup person. That's always a good idea. Communicate those expectations. So your client knows that, hey, this person I'm going to be choosing, they have expectations, they have duties, they have responsibilities, and they have a role and responsibility if they are going to be that healthcare proxy should something happen, right? So those are things that we should be communicating with our clients about. Okay, let me go. And after your client has answered these questions, it's time to strategize and execute the document. We have to get the job done. Make sure you're following up with them. You don't want your client to just sit on the information and not proceed with the document. The danger with that is you do not want something unfortunate to happen to your client while they're sitting on the information and not moving forward. You know, we have all heard stories about that happening, and we just want to make sure that we're on top of our clients and making sure they know, like, hey, it's not a rush, but it is an urgent concern. We need to get you in here and get this document done. So with that being said, a good thing to do is make sure you set reasonable timeframes for your clients. Don't pester them, but say, hey, I know you have a lot to deal with. You've got your intake forms. Can we get you in here next week? If you have questions before your next Friday appointment, call me on Wednesday so I can answer those, so we'll be ready to go on Friday. Keep in mind, upon execution of these documents, they will require notary and witnesses. The document must be clean, concise, signed, and dated accordingly. I like to keep my forms very, very much on the CCC side. What I mean by CCC, clear, cut, and concise. That makes it easy for your clients to understand. Also, if it's litigated in court, whatever judge or jurisdiction you are in, they will see what was written and what the intent of the drafting was at that time. So keep it very concise. Make sure it is signed and dated. Make sure that you're on top of your forms. Now, keep in mind another thing. Some people have power of attorneys and they have no idea how to use them or what to do with them after they get it. They're like, oh, yes, I got my power of attorney, I'm set. But they don't know the purpose of it and they don't know what to do with it. So here's where you do your legal education with your clients. You're going to explain to them that they'll need to have a conversation with their proxy about their duties, responsibilities, and role. Absolutely. So, in addition to having those conversations, to be prepared, you need to let the client know they need to keep their original power of attorney in safekeeping. They need to ensure that the power of attorney agent has copies and understands the document and what their role is. And then afterwards, you can scan, make several copies, turn it in on file at any medical center, hospital, doctor's office, or treatment facility in case an audit occurs or in case the power of attorney is litigated by other parties. Also, ensure that the proxy agent understands and acknowledges and agrees to do this. That's an important part. They have to understand what they're supposed to do, how to activate it, and they also have to agree to the responsibilities that's dictated within the document. You need to ensure that the grantor understands the process of destroying or changing the healthcare power of attorney. So if the agent, they act like at first they were on board to do it, and then they change their mind and say, hey, they tell your client, hey, I don't think I'm in for this. I don't think I'm organized enough. I don't think I can handle this. Then that means that there's another appointment between your client and yourself to establish who the new person is. Or if they haven't selected a backup, we need to do a new document. And it's important that we explain to the client about the communication responsibilities. The client would have to have that conversation with the intended agent. The power of attorney will have to accept the responsibility. Power of attorney will need to understand their roles, duties, and responsibilities. So all of these are conversations that will need to be had between everyone involved. Okay, so moving right along as it relates to the financial needs. Ensure your client has a financial power of attorney in place as well. It is appropriate to follow the same structure and ask some of the same kinds of questions, except you're going to ask more so about debt to income ratio, the types of assets, names and qualities of the potential proxy. You'll have to ask them, is there a desire for you to have a primary beneficiary, secondary, or tertiary person? So with the financial power of attorney, here's some of the things you can discuss with your clients. The purpose of the financial power of attorney is where you would need to start. Let them know what the purpose is. What it is a legal document that empowers a designated agent to manage the principal's financial affairs when they are unable to do so themselves. It allows the agent to handle various financial tasks such as paying bills, managing investments, assessing bank accounts, ensuring that the principal's financial obligations are met during periods of incapacity or unavailability. They're also able to manage and speak with the financial advisors. Also, those kind of things with getting balances on certain assets. So, when you have that financial power of attorney, you're managing that for that client. The agent would have to help manage those financial responsibilities and financial information and financial dealings for your client. So it's very important. It's necessary for maintaining everyday living expenses, bills, management of assets, and funds. Some advice here would be to conduct the consultation dialogue with open-ended questions. Let your client speak what's on their mind and listen to what they say. And once it's ascertained that, hey, you're going to need a financial power of attorney, that will be where you go with the next conversation. Similar to the healthcare power of attorney, on a financial power of attorney, you are wanting to discuss the role of the agent and ask for recommendations. Ask your client for potential names of individuals who may be available and options for a primary and backup individual. This person will need to be trustworthy, accessible, honest. They need to have some way of being business savvy and know how to do things, right? So you don't want your agent, your client to choose an agent that is lazy and is not familiar with how to get things done. This person, this power of attorney, this agent, they're going to have to be a go-getter, and you're going to have to tell your client, hey, we need people that can get things done, whether it's going to the bank, getting a bank statement, calling the creditor institution to tell them that the payment will be late, or to do a electronic payment, or to draft, or send wires, financial wires on your behalf, your client's behalf. That person needs to be business savvy. That person needs to be a go-getter. That person needs to have transportation and be able to run errands on your behalf, make phone calls, send emails, all of that. So this is a very important thing that people overlook, because sometimes your clients will say, oh, I want my granddaughter Susie to do it. She's the sweetest. Okay, yes, Susie may be sweet, but can Susie make sense of a bank account statement? Can she balance the budget? Does she know how to make electronic payments? Does she know how to talk to creditors? Is she able to send emails on your behalf? Can she go to the bank and get a bank account statement? Does she know how to do these things? And that's something you need to remind your client about when you are having a consultation with them, okay? So after we have that established, it's time to strategize and execute the document. Just as we said earlier, with the healthcare power of attorney, with your financial power of attorney, set reasonable timeframes for your clients. Make sure you are following up with them, and set a follow-up appointment and keep the time frame goals. Continued. So you also have to explain how to utilize the financial power of attorney. Keep your original document in safekeeping. Ensure that the agent has access to copies, digital versions. Scan and make copies, and you'll need to turn these into the financial institutions. That's what the slide should say, the financial institutions to keep on file, such as your client's primary bank. In addition, you must explain to your client about communication responsibilities. Your client will have to have probably multiple conversations with the intended financial agent that they will be using. That agent will have to accept the responsibility after understanding what is involved. And then the agent will need to understand their role, duties, and responsibilities accordingly. So that's a very important part of this. They have to know what the role is. They have to understand it. They have to be capable, and they have to accept it. And there has to be those conversations ahead of time. Moving right along to planning priorities, values, religion, and culture. So with estate planning, there are different implications that involve estate planning if the person is highly religious or into a certain cultural practice. And so we'll talk a little bit about what that may be, because when you have a person that is highly religious, those individuals, they often consider their faith when planning their estate as religious beliefs. It kind of signifies the impact that their decisions will have about their wills, trusts, and end-of-life matters. Some people who are of a different faith may not believe in being on a ventilator because their religion prevents them from having access to life-extending machinery, right, and medical practices. So if you have a person of a different faith that doesn't believe in that, that's your client, they're going to come to you with the healthcare power of attorney, and they may be the person that says, do not resuscitate. And they want it in bold letters because that is against their religion. So we have to keep in mind that some people of different faiths and religions and different cultures, they don't believe in all of that stuff, okay? So we just have to be sensitive of that. It's not going to really affect your practice in a negative way. You just have to be aware that it may be a discussion. Also, in addition to that, many faith-based individuals, they may want some kind of ethical directive put into their will, a paragraph stating certain ceremonies that have to take place upon their death, that you would have to, as their attorney, draft. You would have to try to draft that into and build that into that customizable will to help give your client what they desire. So that's one thing you need to kind of keep in mind about the religious part and culture. And it's important, like I said before, when you're consulting with your client, that you give them an opportunity to speak, take a pause, listen, take notes, and then respond to them with what kind of legal services you can provide for them to make sure that they get their goals, right? So learning to incorporate their values. Some people are extremely family oriented and they have a very strict way of how they want things to be done and what family members can attend the funeral and burial ceremonies. So you may have to incorporate a list of individuals that, you know, your client says, hey, these are the people that are allowed to be in the funeral. These are the people that I don't want there. You know, I want it to be closed. I want it to be open. So those are things that you have to think about as well, because sometimes those clients will have you draft that information into the will and you're like, whoa, okay, this is a lot. So just keep in mind that may happen. And also consider cultural impacts, the cultural significance of, you know, certain kind of cultural garments that they may want to be buried in if they are from, you know, their heritage is from Africa or Asia. They may have certain cultural significant garments that they want to be buried in. And these clients will be telling you that, and they'll want that particular part to be drafted into their will. And you're like, oh, okay, this is different. So it's nothing bad. Just be aware that these things can happen. Your clients do prioritize the things they prioritize. And as their attorney, we have to know that these topics may come up whenever we are meeting with these potential clients that eventually become our clients. Next, speaking about travel and citizenship. As it relates to travel and citizenship, these subtopics can affect your estate planning practice. The reason being, for travel, sometimes clients who have active or alternative lifestyles or in different kinds of exciting activities. Sometimes when they're traveling out of state or out of the country, that may trigger an estate planning need in their mind. They may have an exotic vacation coming up where they plan to skydive or parasail, or they're going to be on a yacht for several hours. And the trip is coming up in a month or two. And they say, you know what? I need to see an attorney. I'm going on this exotic vacation. We're going to be snorkeling. We're going to be skydiving and doing all of these things. So I need to get with an attorney ASAP before my trip happens. So they may come to you and say, hey, attorney so-and-so, I'm going on this trip. I need to get a will done. I need to get some power of attorney documents done in case something goes sideways while I'm out of the country, or in case something happens where, you know, I'm not able to return back to my status quo. Okay. Client travels can establish deadlines. So like I said, that same client has a trip coming up in a few months. They may come to you and they want it done before the trip happens. And, you know, I can't blame them for that. But as attorneys, we have to balance our workload and prioritize what we can to help our clients out. So I feel like it's always a good idea to push and get those deadlines finished for your clients before the trip. Okay. And we also have to discuss accessibility for execution. Make sure they know, hey, if we're going to get this done before your trip, I'm going to need you to be by the phone in case I have questions. I'm going to need you to be flexible coming into the office. I need you to make sure you're responding to all of my emails as soon as I send them to you, because we're on a tight timeline crunch and we need to get these documents done. So just keep in mind, when clients are traveling, sometimes that's going to trigger their need to come to you for these documents. The second part of this subtopic is about citizenship. As you all are probably aware, there's a lot of heavy focus on immigration and on documentation, documenting people's citizenship in the United States at this time. I think this is important to discuss because you may live in a city that is diverse and have international clients who have dual citizenship or who have the permanent residency cards. And so you kind of have to understand that client status in case something were to pop up that you're not really expecting or they're not expecting. Because in today's climate, we do have such a focus on immigration, right? So sometimes immigration concerns will trigger estate planning needs, just as travel concerns can trigger estate planning needs. The reason why I say that is sometimes you will have clients that are in the process of getting their documentation, or they came here on like a student visa or some kind of work visa, and they have to get extenuating documents to get permanent residency, and they come to you and they have a family and they're like, hey, I'm going to just make sure I get a will done and get a power of attorney done in case something happens where, unfortunately, if I am deported or if I'm incarcerated for something, the bills can be handled. I won't lose everything while I'm trying to get this paperwork cleared out and get my documents together. And so sometimes a person's immigration and citizenship status can trigger their need and their concern to have an estate planning document. And also family planning needs. When a person or a family is here in this country and they're trying to get family that is in another country over here, they're going to have to talk about documents that potential extension of the family may need once they get over here as well. So just keep that in mind. And we're going to transition over to a question. We do have it. Thank you guys for such great participation today. We have a question from our audience. Do states generally enforce these provisions in the will, or is it largely left in the discretion of the client's family? Okay, that is a wonderful question. So how this works is, okay, let me reread the question in case anyone did not hear it. Do states generally enforce these provisions in the will? I'm trying to figure out which provisions. They may be talking about the cultural provisions, or is it largely left in the discretion of the client's family? So really the client's family, the beneficiaries, will carry out certain bequests from your client. Okay, yes, she clarified the provisions about funeral requests. So basically at that moment, the client's family would largely be left in the discretion of carrying out the final bequest. Okay, so what would happen is the client family would take that and run with it as far as the funeral requests go and about what's drafted in the will. So once that happens, usually everyone's on the same page. Now, where the law jumps in, this is the tricky part. If things don't go according to the will or how other third-party family members thought it should go, sometimes they will try to litigate what's in the will and try to get the courts involved. But by the time that happens, by the time they can get some kind of emergency petition to look at this will and look at the request within the will, by that time the event had already been had and the funeral would have already been finished at that time. But that is a very good question, because sometimes you will have third parties jump into the mix and they will try to litigate something that they don't agree with, and they will likely have an opportunity to go in front of a judge and explain why they believe that something was not correct. And that's why it comes back, it pivots back to us attorneys to make sure, hey, we got the original documents. Our client knows where, the beneficiaries know where their copies of everything is located. So when it comes time to litigate, we have this clear cut and concise document that we drafted for our client, and that's going to save the day, so to speak. But that is a wonderful question, because that is a good point. Sometimes you will have family members pop up that you hadn't seen that no one's seen in 15 or 20 years, and they show up, making a tussle about how things are done, and your client's family members are saying, hey, this is what they put into the will, this is what they wanted, this is the final bequest and how they wanted it to be done. And so that's where, as attorneys, we have to really listen during that consultation part and have our documents on point. So if that third party person pops up and they're trying to make a tussle about it, we have the document. The document's going to save the day and keep that drama, the family drama, and that confusion way down. When you have a document, that document trumps people arguing, because if it's an argument at the funeral, you can call for security, and then security will come and check that family member, that third party person that's causing a tussle, and then your client's beneficiaries will come and say, here's this beautiful drafted document that said this is how they wanted it to be done. The police can escort that person out if they're causing drama. Okay. So that is a very, very good question, because a lot of times these things can happen. And a lot of times these things have happened. So as an attorney, definitely make sure that your forms are on point. Make sure that these agents, these proxies, these beneficiaries, make sure they have the importance and know the importance of saving these documents. I tell my clients to make sure that their agents have the digital version saved on their phone and emailed to themselves, and also make sure that they have the paper with them when they make these big, plans and they have these ceremonies, so that they are protected and they have the evidence that they need. Okay, so I hope I answered that question. I'm sorry if it took a while. Hopefully I answered that question for you. Let me see if there's anything else. Okay, I think we are clear there. Great question. Thank you for the participation. Yes, you're welcome. Thank you so much. So this next one is about family dynamics, prior marriages, and stepchildren. This kind of segues into our last question, and it's a beautiful, beautiful transition into this subtopic. So in being estate planning attorneys, a lot of times you have to identify the family estate needs, like what this whole family needs. Because a lot of times your clients will come to you, you do a will for the father, and then you'll do a will power of attorney for the father and the mother, and then the great auntie that doesn't have her stuff together. And so coming together to identify your client's needs and what that core family member's estate needs may be, it's very important. Another thing is reconciling family members. That involves children from current marriages and previous marriages. And we also need to discuss the importance of DNA in family paternity, because when you're consulting and you're asking your clients questions, which is part of what this whole topic is today, is what kind of questions and what we need to ask. Sometimes you'll need to ask them, okay, so you do have these children. Do you have stepchildren that you adopted? Do you have other potential children that you may not know about? Is there a chance that someone mothered a child of yours, and that child may come forth should a will, be executed. So those are the kind of questions. And I know it's kind of tough and it's kind of sticky to ask those kind of questions to your clients because you don't want to offend them, because your client may say, well, I'm very chaste. I never went outside my marriage. I know what I did. I know what I didn't do. So you really have to be very careful on how you finesse that question and how you ask your clients about these things. But you do need to ask them because they may be like, ooh, man, when I was in 20s, this one girl said that I may have fathered her child. I need to check on that, So just to be sure, just make sure that you at least cover your bases because you don't want something to happen and where, it comes back to you as an attorney and the person says, well, you never asked me. You never asked them that question. So that's where, taking good notes and asking those kind of questions come into play. Also about adoption implications for stepchildren and parents, because sometimes you will have a client marry and come into blended families. Now more than ever, I think it's said in the United States, there's 40% of families are now blended, which means they may have children from a previous relationship and they intermarry and that person has children from a previous marriage. They intermarry each other, and so they have children with each other and children from other relationships. And so these families are blended, and all of these individuals are living under one roof together. So you kind of have to ask those questions like, who got adopted? Are you in the process of adopting these stepchildren? So that's, some those conversations you have to really ask. And the reason why you need to ask is that in wills, there's a part where it talks about your children. And if they're stepchildren and you've adopted them, legally adopted them, they are your children. And they need to be accounted for in these wills. They need to be spoken about in these wills. Okay? They need to be claimed as your children. You're claiming them on your tax returns and you're claiming them in school and you're taking them back and forth to volleyball practice and you've got paperwork on these children. So when it comes to a will, you're talking about your biological children, but that client forgot to talk about their adopted stepchild. That's going to cause problems later on. So definitely make sure when you're in those intake rooms with your clients that you're asking those questions because that definitely makes a difference. And I'm going to add another discussion to this. Acknowledgement of bonus children in the law. This is a new and emerging part of law because sometimes in life, we will love a child that is not biologically ours, and there's no legal ties. We may not have been married to this person, but we just love this child, and this child doesn't know who their biological mom or dad is, but they never were formally adopted, and maybe they were children of the state, put it that way. And there comes a loving person or a loving couple that comes and takes that child in and loves them and financially supports them and is there for them. So we also have to have that discussion. Is there a bonus child in the mix? And did you legally try to adopt them, or what is the status with that? Because some people will want to leave that bonus child some money should they pass away. And then the biological children become jealous or envious is the better term of this bonus child and say, well, they're not even your blood relative. However, the draftee was like, well, we have a bond with that child. So, we have to really account for these marriages and these stepchildren, and the definition of family has expanded so much. So you may not think that they're family, but the client feels and knows in their heart that they're family, even though they're not biologically related to them at all. So those are things that we need to consider and think about when we're drafting. And also when we're consulting with our clients. Okay, so moving right along, creditor issues and spending habits. Drafting your estate documents to address creditors and potential bankruptcy. So really here, That's more so related to trust. Sometimes when you have an individual, sometimes your client may want to protect a spouse or a relative that they know has spending issues and has creditor issues, and they will get a trust in order to protect that person from themselves and their bad habits, to try to avoid bankruptcy and those kind of things. Using title strategy to protect family assets. That's another thing that attorneys are doing a really great job at doing. The main example that I can give could be like the father of the family knows that the wife kind of has the issue with her finances. So instead of titling the family real estate property in both names, he will title it in himself and leave that real property in the will to the children. And so the mother will stay there, and it'll be like how can I say it? It will be like a makeshift life estate interest. So she could stay there for the rest of her life in that property, but it won't be in her name. And something may happen to where she will have to receive nursing services. They can't take that real property out of the family or away from that wife, because the wife's name is not on that real estate property. It goes straight to the children. So some attorneys are using those kind of titling strategies to protect family assets for their clients. And really that becomes more of a strategic approach to how to give your legal services to your clients to help them out. Then there's other ways like using trust to protect wealth and assets, especially from taxes and excessive taxation. You can use trust to protect those wealth and assets, and also build in spendthrift provisions and strategies. Like I said before, in some estate planning, when you're doing your trust, you can put spendthrift provisions to protect the wealth and assets, especially when you have that person to receive it, and they're spending. You see them, in Las Vegas every weekend. They're at the casino every weekend. You can protect that trust. That's kind of where they come with the term trust fund baby, things like that. Sometimes there are entitlements that people feel that they're entitled to do these things. And so as attorneys, we can draft those trusts to help our client protect the future generations from excessive taxation and from spendthrift things, by making sure that we have an airtight way that we are doing our estate planning for our clients. So these are just a couple tools and tricks that you can investigate and learn more about to help you with dealing with your client and giving them the best legal services that you can. Next is beneficiary needs and dynamics. This part talks about defining the beneficiaries, the insurance beneficiary, the trust, communicating with clients about their roles, rights, and duties. That's basically clients in attorney education, where you as the attorney is communicating with the client about the roles of these beneficiaries, what they're supposed to know, what they're supposed to understand, and what they're supposed to do. Understanding pitfalls. That's another thing to communicate. When you're asking your client questions, we need to know if there are some troublesome family members that will try to intervene. The reason we need to know this is because if we know that there are some troublesome family members that want to intervene with the intended beneficiaries, we can draft on the front end to help protect those beneficiaries, right? But we can't really do extra drafting and extra strategy as attorneys if our clients have not disclosed this information. So that's where the consultation part is so important. We have to ask these uncomfortable questions sometimes. Identifying primary and secondary beneficiaries. That's basically if one can't do it, who is the secondary person? And then finally, we discuss family dynamics and choosing beneficiaries. So, in each family, we typically know the individuals that can handle the business and get things done. Your client will typically come to you with a couple people in mind, but you also have to educate them and say, hey, evaluate who you choose based upon some of these things that we have discussed today. Who is trustworthy, who is a good listener, who is accessible, who has transportation, who is a good comprehensive person. They're thorough, they're detailed, you can trust them. They're easily accessible. They are steadfast in their communication. They are not overly emotional. They can still think logically. These are some of the things, the family dynamics in choosing, who's going to handle these things, who's going to be my agent, who's going to be the beneficiary. What planning tools are already in place? We discussed insurance, power of attorney, wills, estate planning. Collaborating with other planning professionals, that is a good idea, especially if you're dealing with $1 million estates. Sometimes you are going to have to collaborate with your client's legal advisor and your client's insurance professional. And that will just have to be okay, because sometimes when you have those $1 million estates, you will have to collaborate with other people. Develop a coordinating plan. Make sure you come up with a strategy, develop a plan. And another thing, you must bundle service and upsell. I hate to say it like upsell, but if they come into you for one thing and you can take care of 3 things for them at one time, I always encourage other attorneys like myself to bundle things. The reason why I say that is, you don't want your client to have to go to one person to change their healthcare power of attorney. Then they got to go across town to update the will. Then they got to go back on the other side of town for their financial power of attorney, when you could have been the attorney that did all 3 things for them. That will save them time, money, resources, and avoid a lot of confusion if you can bundle those services together. Now, if they decide that, hey, I have a contract attorney, I want to do my business contracts on the other side of town, that's fine. But when it comes to estate planning, you kind of want to be the primary person. So if something happens and a new baby is born in the family, or they have to change their beneficiary, they have to change their agent, their proxy agent, you want all 3 of those services to be updated pretty much at the same time, so there's not contradictory information and documents floating around should something be litigated. So I say, if you're doing one thing for them, estate planning, try to go from start to finish. Do all services for that particular client. It's going to save you time, money, resources. It's going to save them the same. Looking at templates and clear formatting, we talked about CCC, clear, cut, and concise. Make sure it does make sense. Make sure your client understands what you did and why you did it that way. So here I have an example, because we are winding down for the presentation. Here's kind of an example of what I would do for a financial power of attorney, kind of like how you would put the names in there, the secondary backup person, talking about the financial affairs, who they designate. Also, just the general language of how a financial power of attorney can look. Yours may look a little different, which that is fine. You may draft a different way that I do, but this is just an example of what your power of attorney can look like. And of course, on the second page will be where they get notarized, is signed and dated, and all of that stuff happens on that second page. Now we're going to transition to a practice question. Feel free to enter anything that you want in the chat. The chat is still open. A potential client comes into your office upon referral by his financial advisor to receive estate planning services. He is Peruvian, married, newly retired, and has real property and investment assets such as crypto, 401k, vehicles, bank accounts, stocks, bonds, account payables. What kinds of questions would we ask him during the initial consultation? You can ask him a lot of questions, but the question we're asking you today is, what kind of question would you ask him during his initial consultation? If we have an intake sheet, what categories would we need to add? So I'll give you some seconds to think about that. What would you ask him? He's married, newly retired. He's got assets. He's financially established. I'm thinking we need to bundle. We need to do that healthcare power of attorney. We need to do financial power of attorney. We need to do a will. We may circle back and see if he needs some estate planning. But I'm thinking we need to do some documents for this guy, right? Because he's got the money to pay. Here's a good one. Do you have a green card? Yes. Like your immigration status. Find a way to ask him that. Like he says, I'm Peruvian. I've been here for a certain number of years. You can say, well, Mr. So-and-so potential client, do you have a permanent residency card? Are you working on becoming a U.S. citizen? Are you looking at moving back there? That's a good question. Thank you, Arthur. Where are these assets located? Yes, we want to know where are these assets located, because we have clients that may own stuff in their home country. They have businesses in Peru. They have side ventures in businesses in Peru, and they have businesses in the United States, and they have freelance gigs that they're doing here part-time. He's newly retired, so he's not necessarily working 9 to 5, but he may have had a side gig that he was doing while he was working. Good job. Another one. Any kids? What are your children? We know that you're married. Do you have children? Do you have stepchildren, adopted children, bonus children? Can we account for these children in the will? Good job, guys. What do you want? Yes. What are you looking for? I, as attorney, I can do your power of attorneys for you and do your wills. Good job. Here's another one. How is the crypto and other assets titled? Exactly. Because you need to know if this crypto business that this guy has, is he the sole owner, or did he have a business partner that is also owns half of it? Is it a 50% interest or 100% interest? And also, how are the other assets titled? The vehicles. Is there a right of survivorship for the vehicles with the bank accounts that he owns? He may have a POD, which is a point of death beneficiary. That could be his wife. That could be a totally different person. We don't know that. That's why we have to ask. So wonderful job. I love this participation.